Have you noticed how often the government of the United States decides how you should live your life? It seems everything from food and drugs to light bulbs in your home are regulated by Uncle Sam. And whenever some bureaucrat deems it necessary, they simply roll out another rule or regulation to clamp down on the American people. It seems, though, that one of those agencies may have bitten off more than it can chew, at least according to the Fifth Circuit Court of Appeals. In the case Louisiana et al. Versus U.S. Department of Energy, the court decided that one of the DOE's rules was illegal, but was it unconstitutional? We'll discuss that next at the Constitution Study.
Love the neighbors and have a few good friends. Every day we're everyday Americans. Oh, every day we're everyday Americans.
Well, hello there, everyday Americans. Paul Engel here with the Constitution Study. This is where we read and study the Constitution, teach the rising generation, be free, teach you and help you defend and assert your rights. Prepare to do so that we can all live free. Now, one way we got to deal with this is dealing with these rules and regulations, which is why I found this court case interesting, but maybe not as interesting or at least as good as we first were led to believe. So let's take a look at this case, Louisiana versus DOE, and see what we can learn from it. When Congress decides it wants to exercise a power not delegated to it by the Constitution, it usually reaches for the General Welfare Clause, Article 1, Section 8, Clause 1. The Congress shall have power to lay and collect taxes, duties, imposts, and excises, to pay the debts and provide for the common defense and general welfare of the United States. They seem to forget the fact that this clause empowers Congress to collect taxes, not to regulate. They also seem to ignore that it only allows Congress to collect taxes for the general welfare of the United States, the very same proper noun used in the 10th Amendment. The powers not delegated to the United States by the Constitution, nor prohibited by it to the states, are reserved to the states respectively or to the people. Does this clause of the Constitution allow Congress to do whatever it thinks would be good for America? Not according to James Madison. While debating a cod fisheries bounty bill in the House, he said, "If Congress can apply money indefinitely to the general welfare and are the sole and supreme judges of the general welfare, they may take the care of religion into their own hands. They may establish teachers in every state, county, and parish and pay them out of the public treasury. They may take into their own hands the education of children, establishing in like manner schools throughout the Union. They may assume the provision of the poor. They may undertake the regulation of all roads other than post roads. In short, everything from the highest object of state legislation down to the most minute object of police would be thrown under the power of Congress. For every object I have mentioned would admit the application of money and might be called, if Congress pleased, provisions for the general welfare." Looks like Mr. Madison was correct. Once Congress believed they could apply money indefinitely to the general welfare, they took over everything, including regulating dishwashers and washing machines. Here's where we enter the case of Louisiana versus U.S. Department of Energy. In 2022, the Department of Energy tightened the regulatory regime surrounding America's dishwashers and laundry machines. Petitioners sued. The department's actions were arbitrary and capricious, so we grant the petition and remand to the department. What led up to the 2022 decision by the Department of Energy to tighten regulations for dishwashers and laundry machines? Why did several states, including Louisiana, Alabama, Arkansas, Kentucky, Missouri, Montana, Oklahoma, South Carolina, Tennessee, Texas, and Utah, file suit? In 2018, the Competitive Enterprise Institute submitted a petition for rulemaking to the Department of Energy, DOE or the department. According to CEI, the department's burdensome energy regulations made dishwashers incapable of, well, washing dishes. CEI asked the department to define a new class of dishwasher under the Energy Policy and Conservation Act of 1975. CEI proposed that the new class should be comprised of dishwashers with a normal cycle duration of under 1 hour. CEI anticipated that the new class might offer better performance than currently available machines, in part because it would not need to comply with the energy and water restrictions otherwise applicable to consumer dishwashers today. Apparently, the Competitive Enterprise Institute thought of a way to get around the DOE's restrictions on energy and water usage. They petitioned the DOE to make a rule that would create a new class of dishwasher that would not need to comply with DOE's energy and water restrictions. DOE responded favorably to CEI's petition. It published a Notice of Proposed Rulemaking, or NPRM, under the Administrative Procedures Act, or APA. The NPRM proposed the new dishwasher class that CEI had requested. In October 2020, the DoD adopted a final rule defining the class as standard residential dishwashers with a cycle time for the normal cycle of 1 hour or less from washing through drying. This became known as the 2020 dishwasher rule. The DoD adopted the rule proposed by CEI. Apparently, DoD liked the rule so much they created another rule for laundry machines, or what most of us call washing machines. On its own initiative, the department then decided to take analogous action on laundry machines, the 2020 Laundry NPRM. The DOE explained that both of its 2020 rules reaffirmed the department's recognition of cycle time as a valuable consumer utility. Does the DOE think it's valuable to consumers to minimize cycle time in such appliances? Apparently, the DoD is more interested in how long an appliance runs than how well. So far, so good, though, until the Biden administration takes office. On the day of his inauguration, President Biden issued an executive order directing DOE and other agencies to reconsider certain rules, including the 2020 dishwasher rule and the 2020 laundry rule. A new final rule, which we call the repeal rule, was issued in January 2022. It revoked both the 2020 dishwasher rule and the 2020 laundry rules. In come the politicians, apparently overriding the rules of the bureaucrats, this time to the detriment of the people who actually purchase and use dishwashers and washing machines. Then a group of states decided to stand up and, if not come to the rescue, at least push back on the repeal of these new rules. A group of states, led by Louisiana, petitioned our court for review of repeal rule. What was the basis of the state's lawsuit? What was the Fifth Circuit asked to decide? Now the merits. While the states make various contentions, we need only consider one, that the repeal rule is arbitrary and capricious. Part of the law Congress passed to regulate how agencies create rules and regulations is known as the Administrative Procedures Act, or APA. Section 706 of the APA requires courts to hold unlawful and set aside agency actions, findings, and conclusions found to be arbitrary, capricious, and abuse of discretion or otherwise not in accordance with the law. If a court finds that an agency acts in an arbitrary or capricious way or beyond their legal authority, it must hold those actions as unlawful, therefore deciding for the plaintiff who sued. The repeal rule falls short of these standards. We discussed the department's inadequate consideration of important aspects of the energy conservation program. Then we discussed the repeal rule's reliance on purported legal error. Things aren't looking so good for the Department of Energy at this point. In 2022, DOE was required to reasonably consider the relevant issues and reasonably explain its decision in the repeal rule. It failed to do so. Specifically, it is unclear that DOE has statutory authority to regulate water use in dishwashers and clothes washers. But even if DOE has water usage authority over the relevant appliances, the department failed to adequately consider the negative consequences of the repeal rule, including the substitution effects of energy and water wasting rewashing, pre-washing, and hand washing. And in all events, the 2022 DOE failed to adequately consider the impact of the energy conservation program on performance characteristics. Basically, the court found that DOE tripped over itself in two primary areas: their legal powers and the impact of the repeal rule. Let's look at these individually. In promulgating the repeal rule, DOE stated that its energy conservation program must promote water conservation and regulate water use. But it is unclear how or why DOE thinks it has any statutory authority to regulate water use in dishwashers and washing machines. First, there's the question of whether or not the Energy Policy and Conservation Act of 1975 delegates to the Department of Energy the authority to regulate water use for these appliances. The EPCA allows DOE to regulate energy use by some products and water use by others. The ECPA does not appear to contemplate overlap between the products subject to energy regulation and those subject to water regulation. Energy first. The EPCA defines energy use as the quantity of energy directly consumed by a consumer product at point of use. and defines energy as electricity or fossil fuels or other fuels. Dishwashers and laundry appliances obviously use energy as the EPCA defines that term. So it makes sense that the DOE can regulate the amount of energy used by those appliances. But the statute defines water use as the quantity of water flowing through a shower head, faucet, water closet, or urinal at point of use. And the four explicitly enumerated water products do not use energy as that term is defined by the EPCA. That explains why Congress said energy use or water use. So first, the court found that the Department of Energy did not have the statutory authority to regulate water use in these appliances under the EPCA. I'll talk a bit more about that later. Now, what about the second problem the court found? Even if DOE could consider dishwashers and clothes washers efficiency in both energy use and water use, the 2020 rules likely promote greater efficiency in both categories than the repeal rule. Assuming both energy conservation metrics are on the table, the states argue, and DOE does not appear to dispute that one important aspect of the problem is whether appliance regulations actually reduce energy and water consumption. Yet the administrative record contains ample evidence that DOE's efficiency standards likely do the opposite. They make Americans use more energy and more water for the simple reason that purportedly energy-efficient appliances do not work. So Americans who want clean dishes or clothes may use more energy and more water to pre-clean, re-clean, or hand wash their stuff before, after, or in lieu of using DOE-regulated appliances. Strike two for the Department of Energy. It appears not only has the DOE gone beyond its statutory power, but in the name of being energy efficient, their latest rules actually promote the use of more energy and water to do the same job. According to the court, since the repeal rule was outside of the DOE statutory authority and did not fulfill the requirements of the policy, that policy is arbitrary and capricious and therefore did not comply with the Administrative Procedures Act. In sum, it is unclear that DOE has any statutory authority to regulate water use in dishwashers and clothes washers. But even assuming the department has that authority, the repeal rule is arbitrary and capricious for two principal reasons. First, it failed to adequately consider appliance performance, substitution effects, and the ample record evidence that DOE's conservation standards are causing Americans to use more energy and water rather than less. And second, it rested instead on DOE's view that the 2020 rules were legally invalid, but even if true, that does not excuse DOE from considering other remedies short of repealing the 2020 rules in toto. While the striking down of the repeal rule is a good thing, there's one very important point the court missed. While the court looked at the statutory power of the Department of Energy, they never looked at its constitutionality. Congress stated the purpose of the Energy Policy and Conservation Act of 1975 within the legislation. The purposes of this chapter are to grant specific authority to the President to fulfill obligations of the United States under the International Energy Program, to provide for the creation of a strategic petroleum reserve capable of reducing the impacts of severe energy supply interruptions, to repeal Title I, Section 1022, to conserve energy supplies through energy conservation programs and, when necessary, the regulation of certain energy uses, to provide for improved energy efficiency of motor vehicles, major appliances, and certain other consumer products, to provide a means for verification of energy data to assure the reliability of energy data, and to conserve water by improving water efficiency of certain plumbing products and appliances. Look all you want, but you will not find the power to conserve energy supplies, improve energy efficiency, or conserve water as a power delegated to the United States. You may be thinking, but what about the International Energy Program? That was probably done by a treaty, which makes it the supreme law of the land, right? No. The Supremacy Clause states, "This Constitution and the laws of the United States, which shall be made in pursuance thereof, and all treaties made or which shall be made under the authority of the United States, shall be the supreme law of the land." Only treaties made under the authority of the United States are the supreme law of the land. The United States does not have the authority to regulate energy or water supplies. Therefore, any treaty that may have been signed is not within the authority of the United States, not the supreme law of the land, and as an unconstitutional act, void. In fact, since regulating energy is not a power delegated to the United States, the legislation that created the Department of Energy is an unconstitutional act and therefore also void. So while the court came to mostly the right conclusion, their failure to consider the constitutionality of the Department of Energy leaves the American people with the false belief that the Department of Energy is legitimate and that their regulations have the force of law. This in spite of previous court decisions to the contrary. From Norton v. Shelby County. An unconstitutional act is not a law. It confers no rights. It imposes no duties. It affords no protection. It creates no office. It is, in legal contemplation, as inoperative as though it had never been passed. Rather than dealing with the unconstitutionality of the repeal rule, they merely turned it back over to the illegal agency that created it in the first place. For the foregoing reasons, the petition for review is granted and the matter is remanded to DOE for further proceedings consistent with this opinion. This is why it is so important for you to read and understand the Constitution for yourself. Not only so you can recognize these unconstitutional acts, but so you can prepare yourself to defend and assert your rights, including the right to have the supreme law of the land faithfully enforced. So here we have yet another problem created by the fact that we failed to follow the Constitution back in 1975 when we created the Department of Energy and gave it the authority to regulate things that the United States doesn't have the authority to regulate. We are living with the consequences of previous actions. Now, it's easy to simply stand back and say, well, what can we do? Well, you can learn your rights. You can know what your rights are and prepare yourself to defend and assert them. How? The way John Jay told us to, by reading and studying the Constitution, doing so diligently. That's what we do here at the Constitution Study. We help you read and study the Constitution. It's why we created the Patriots program, so that whatever groups and organizations you're a part of, you can join the Patriots and we can help you run those programs more efficiently, give you the constitutional tools to do what you want to do better and have it stand up, at least supposedly, in court. Stand up to the law, stand up to the Constitution. I'm not saying it's easy and I'm not saying there aren't issues, there aren't consequences. But I have to ask you, are you willing to sell your children into slavery to avoid dealing with the problems today? That's what got us here. The repeal rule, the dishwasher and laundry machine rule, all come from 1975 and the belief that the United States had the legal authority to tell you to regulate your water use. If we go back to the beginning, we fix that problem. But we're not going to get there all at once. We start by making sure that our cities, our counties, our towns, and our states stand up. And that's what we're trying to do here, is give you the tools to do that. Now, if you have any questions or any topics you'd like me to cover, hey, go to the website, constitutionstudy.com, click the Ask a Question button. I'll be more than happy to. If you'd like me to speak at one of your events, either online or in person, go to the website, find out the About Me, and check and request an interview, request a speaking engagement. I'd be more than happy to. And if you don't charge for the event, I won't charge you to show up. I will ask for some help with the travel and living costs, but I'm not asking for a fee if you're not charging people to show up to the event. Let's figure out what we can do to help educate the American people so we can all enjoy the blessings of liberty that our founding fathers and so many Americans have fought and bled and died for. We can do that by coming back next time and joining us to the Constitution Study.
Love the neighbors and have a few good friends.